ensayas rápido, no te sabes con el pie. Lo ensayas rápido, no te sabes con el pie.
Welcome back to Civil Discourse Now. I am not Paul Ogden.
And I'm not Mark Small.
We're here talking today about the Affordable Care Act decision handed down by the United States Supreme Court on June 28th. Our guests are Jeff Cox, who's an Indianapolis attorney who's been on the show several times, and Adam Lenkowski. Adam, I had to look at the paper to, it's a long name. You get beyond 5 letters for me, and my memory is difficult.
Oh, he's lucky if he gets up to 5 letters.
Thank you, Jeff. That's we're discussing the Affordable Care Act decision that was penned by Chief Justice Roberts.
And he started off with the Interstate Commerce Clause in his opinion.
Yeah, and what was interesting, I thought, in news coverage of that, a right-wing congresswoman from Ohio shrieked happily in the street across the street from the Supreme Court building. She had somebody in there had been tweeting her about the decision, and it tweeted, "Commerce Clause struck down." And so she went, "Oh, they've struck it down on Commerce Clause." Well, if you're in court and a judge is reading an order that relates to a cause that you're in and starts out talking favorably for your side, that normally means that the balance, the bad side's going to come up in the end of the order. I mean, that's one thing that happens, and that's what happened here, because Roberts talked about how the Commerce Clause could not be invoked to justify, as he said, something that was not in commerce.
Yeah, and I think we should bring our guests in at this point. Maybe Adam can speak to that. And they consider that a win. Some conservatives do that.
Well, there were basically 2 different grounds to challenge the mandate. The first one was on whether it was proper under the Commerce Clause, and basic argument was that Congress is trying to regulate commerce that is not actually occurring. They're trying to regulate the non-existence of something, either that or they're trying to create commerce itself and then regulate it.
Yeah, by ordering people to buy insurance, they're actually creating the commerce and then regulating it.
And Roberts distinguished Wickard versus Filburn case that we attorneys are all familiar with from this situation, did they not?
Yes, they did. Wickard was a situation where someone actually wanted to grow the wheat himself.
And use it himself.
And use it himself. In this case,
and they said that is involved, that does affect interstate commerce because it means you're not buying wheat.
Right. In this case, it's more kind of passive non-activity was what's going on.
Right.
So that's why you can regulate actual commerce, but you can't regulate non-commerce.
Now, is this something, and it throws up into her guess, is this something that could be used in future cases? Because I know that we conservatives, I say we conservatives, not Mark, have long complained about the overuse of the Commerce Clause.
Well, you see, here's the problem with that. While they may have said that you can't use the Commerce Clause to justify a particular type of action, they also vastly expanded the tax clause.
Okay.
And I think what they've done with that actually exceeded any power or was not consistent with any previous precedent. What they had done, Roberts basically, he relied on a number of different cases in concluding that the mandate was proper as a tax. Those cases, one was a certain kind of user tax, one was a tax on child labor, and one was a tax on kind of shipping materials outside of a state.
But he also looked, though, at the qualities of those of whatever you want to call it, whether it's a penalty or tax. He looked at the qualities of it and how it was collected. And in the statute, it is collected by the Internal Revenue Service, and there's no assessment, but they talked about how it was assessed was through the Internal Revenue Service. So he was kind of bringing that in at the same time as having to make the argument after the government, after the people who were against it had or supported the statute had said it wasn't a tax.
Well,
emphatic.
Here's the problem. Clearly, it can still be a penalty regardless of who is actually assessing it. I mean, even if the IRS is assessing it, that doesn't mean it's per se it must be a tax. In theory, they could also make it a penalty. The problem with the cases that the Roberts majority relied on is, this is actually kind of where this is intertwined with the Commerce Clause, is that they all involved people who either wanted to engage in some sort of activity which subjected them to taxation, or actually were engaged in that type of activity. This is simply saying, you've got to pay it, and you're not doing anything to begin with. So in my opinion, that made it a penalty, not a tax.
But even if it's a tax, one could take a position it's a tax and still think it goes too far, can't one?
I don't think that was particularly addressed. I think once a tax has been found to be proper, then under that circumstance, then it's probably almost unlimited.
It's also taxing non-activity.
That's exactly what I was suggesting.
That's a pretty not limiting power.
Well, I believe that the dissent talked about how soon the government would be able to tax whether we breathe or whether, just the basic activities of life. But that was addressed in a prior work by, they were not judges, but they were four musicians, Lennon, McCartney, Starr, and Harrison in Taxman, where, we'll tax the street, we'll tax everything. They were rebellious against the 95% tax rate that was in Britain at the time, or 90%. But in this, the dissent hit on, they'll tax the air you breathe, and they also made a point about broccoli, because, I think that Justice Roberts brought in the whole broccoli argument, that if we find that it's healthy for you to eat broccoli, and it's good for the society, because the people who don't have health insurance are causing people who do have health insurance, or who do pay taxes for public hospitals, to pay more money when they have to go in and get.
Well, Roberts didn't bring in the broccoli argument. The broccoli argument was brought in by those opposed to Obamacare, and the mandate specifically that you buy health insurance. And their point was, if you take this to its logical extent, the government can force you to buy broccoli. It can require you to buy broccoli because it's good for you, even if you don't like it. And even though it's not an enumerated power, they can force you to buy broccoli. And was that the intent of the Constitution, including the Commerce Clause, when it was written?
Well, and Ginsburg addressed the broccoli argument. It was brought in by Roberts. Ginsburg addressed it by saying, well, you can require people to get broccoli, but it doesn't mean that they're going to eat it or they're going to cook it properly. And she went through variations of the broccoli thing, which kind of blew me away when it first came out in the argument.
But it's all ridiculous.
You don't cook broccoli anyway. Eating it raw is the best way to eat it.
No, you cook it with butter sauce.
Okay. We'll do a cooking show sometime.
Yeah, and we'll discuss broccoli. But right now we're discussing the constitutional ramifications of broccoli. That's different.
I think the taxing power, even if it's called a tax, to me, what's the limit on the power of the national government at that point? They can just tax whatever they want and say, we want you to do this, we want you to do that, even though it doesn't fall under the enumerated powers.
But look at what they did with the highway monies in the 1980s. It was Dole versus whomever. When Reagan wanted to up the drinking age to 21, which has been a disaster.
Yes.
Yeah.
And said, look, to the individual states, you either increase your drinking age to 21, or we're taking away 5% of your highway funding.
And that actually leads to our next topic.
Well, that didn't go to the definition of what a tax was, though. That just went toward what states
punish it.
Right.
They're raising money. They're giving it to the states. Then when the states they want states to do something and say, you got to do it or we're going to cut off money. In fact, that's what's happening with the second part of this decision, which I found interesting. The Medicaid part. The Medicaid mandate where states had to expand their Medicaid or face the penalty of losing all their Medicaid funding. The court said that was unconstitutional. And what I found very surprising, we had two liberals on the court that actually voted with the conservative majority on that. Kagan and Ginsburg, not Ginsburg, definitely not Ginsburg.
Sotomayor.
Breyer.
No, Breyer did.
Breyer.
Was that a deal? I mean, was that a deal to get the...
That is something I'd like to talk about in the next segment about should justices on the Supreme Court or any court be trading votes.
It's not should they. They have been ever since the court came into existence.
Well, just because they're doing something doesn't make it right.
Oh, well, I know, but they're trying to figure out, have we exhausted the Commerce Clause, so to speak?
Well, I think we exhausted the Commerce Clause. We also talked about the taxing clause, but the Medicaid thing I find may come up in other cases where you're trying to say, states, we want you to do something, or like with the highway money, they all of a sudden say, if you don't adopt a 21-year-old drinking age, we're going to cut off your highway money.
I think for the commerce and taxing issues as addressed in this opinion, we should probably just ask the question and leave it out there. What is the limit on the government's power?
I like that.
After this opinion,
68%.
what is the limit on the government's power?
68%.
That is a random number you just made up.
I believe that the studies will support me in that.
I think Mark's comfortable with absolutely no limits on the power of the national government to do anything. Am I not correct?
Wait a second. During times of war, we've seen periods of time when the federal government has had no limits placed on it virtually. During World War II, World War I. President Lincoln suspended the writ of habeas corpus during the Civil War. So there have been times during which the government has known no limits. I don't advocate that.
But those periods of time where the government had no limits were limited. They were limited to specific circumstances of war. Now, for the healthcare mandate, this is not a war. At least not that I know of.
I understand, but we do have, and this is interesting about Justice Ginsburg's dissent, or concurring opinion, where she says, essentially, this is, well, it was a dissent on the expansion of Medicaid. She said, this is a really big problem. This is a huge problem. Medical costs are spiraling, and all these people that are not paying for health insurance are causing everybody else to pay more in taxes or higher insurance premiums. And she said, we've done this before, and we've allowed this before. That was the extent of the argument that I perceived. I mean, it wasn't...
That's a policy argument. That is an argument for the Congress. It's not an argument for the courts.
I understand.
The court's job is to determine whether it's constitutional or not.
But when you look at the fact that Congress is not doing anything right now because they're frozen, then when is it that the Congress steps in and looks at a statute like this and says, well, what are we going to do? And I think a great example of what they did here in terms of a compromise could be compared, although not on the same scale, still in terms of the costs on health care, to the Dred Scott decision. We're at the end of the third segment. We'll be back in just a minute.